Hello again. Thank you for joining me for another episode of You Would Think. We are covering day 16 of the Lindsay Clancy trial. A little background for any newer viewers. Lindsay Clancy is the Massachusetts mother of 3 who strangled her children and then jumped out of her second-story window about 20 feet down to the ground. Fell on her head and paralyzed herself. The prosecution is saying that she did this deliberately because she didn't like the life that she was living anymore and she just wanted to annihilate her own family and herself. I don't know. Make that make sense. And the defense is saying that, this is a well-documented, case in her mental health history of trying to get help with some of these problems, that she was going through postpartum depression and she was suffering from a postpartum psychosis at the time the crime occurred and therefore should not be held criminally responsible. Otherwise known as the insanity plea. Of course, now we're not supposed to say insanity. We're supposed to say in way of mental disease or defect. Say what you will. Full disclosure, I am not an attorney. I do not have a law degree. My degree is in forensics and crime scene technology. I've always had I like watching trials and true crime cases, and it's become a little bit of a hobby, so I thought I would make a YouTube channel where I can discuss some of these trials with you and get your perspective and just basically have someone to talk to about it that like them as much as me. So please like and subscribe so I can continue to bring you content, and put all of your comments and questions in the comment section so that I may address them. And let's jump right in. Back on the stand to finish his direct testimony from yesterday. And then it was time for the prosecution to cross-examine him. And remember, Dr. Zeizel was the psychiatrist that was treating Lindsay, and he was the one who came to see her in the hospital after the crime and let her use his cell phone. And at one point there was an accusation that he's the one that told Lindsay to tell Patrick on that phone call that she had heard voices. But this was never corroborated. It was nothing more than speculation, and that's it with that. One of the things that the prosecution did was asking Dr. Zeizel if he read the entire report, which consisted of 7,000 pages. And he said that he skimmed through it. So she chose a bunch of excerpts and entries, read a bunch of them, and from the information in those records. But you'll see that she also points out that, like, she would read an excerpt and she would say, "Do you remember that?" And he would say, "Not specifically." But what she was doing was she was correlating all the excerpts that she was reading with the children's birthdays or the anniversary of the day the crime occurred.
In talking about your review of records, You indicated that there are several thousand pages of Tewksbury Hospital records, correct?
7,001 page.
And did you review all of those?
I would say I looked through them, but I did not read every word on every page. They do have a tendency to hang together and are replicative as well.
Were you aware that on May 26, 2023, that the defendant was observed by staff in a note stating that she was visible along the unit hallways, self-propelling her wheelchair with her one-to-one staff, that she had a visit with her mother who brought dinner for her, they ate and played games during the visit? Are you aware of that?
On May 26th.
May 26th of 2023.
May 23. So 3 years ago and a few months? I don't know that. I don't remember.
That would have been approximately 4 months after the incident and on the date of Callan's first birthday, right?
Yes, but you asked if I remember that event, and I don't.
You don't, or you do?
I don't remember that she was seen with her mother on that day who brought food, and she was seen using a wheelchair to travel down the hallway at the hospital. I don't remember.
If I tell you that was read from page 176 of the Tewksbury Hospital records, would you agree with that?
I would not doubt that.
And on December 24th of 2023, were you aware that the defendant was observed at Tewksbury, monitored on one-to-one for safety, that she accepted medication, meals, and snacks, she spent time in the TV room or sitting outside her room, utilizing phone, and visited with family? Yes.
Honestly, I don't.
And that would have been Cora's birthday.
Okay.
But would you agree with me that if I read that from page 613 in the records, that that would be within that 7,001 page of the record?
I would not doubt that.
How about on January 24th, 2024, where she's observed in a note from Tewksbury State Hospital on page 674, saying, where the note reads, patient was visible in the milieu, engageable with both staff and select peers, patient accepted select medications as her baseline, that she was pleasant during interactions, self-propelling in wheelchair in the halls, spending much of the morning and early afternoon in her room and hall on her electronics. Do you recall reading that record?
Not specifically.
And January 24th, 2024 would have been the year anniversary of the incident, correct?
Yes.
But if I read from page 674, you would agree with me that that's part of the Tewksbury record?
Yes, I believe it's part of the record.
And on May 26th of 2024, from page 922 of the Tewksbury record, patient monitored one-to-one for safety. She's been monitored for hypertension, accepted medication, says BFK and snacks. She spent some time in the TV room or sitting outside her room utilizing phone. Would you agree that that's a fair reading of page 922?
I have no reason to doubt that.
Okay. And that she's also observed on that same day, visible on the unit while utilizing her phone outside her room, was able to make her needs known appropriately. Patient was observed playing dominoes with peers in the TV room. That was later in the day on May 26, 2024, which would have been Callan's second birthday.
I would believe that that record's probably accurate. I don't remember looking at that record specifically.
You know, one slight win was that just about every excerpt that she did read from that report, when asked if he remembered that, he said he did not remember specifically. And for the first time, at least that I've seen, the camera had panned to, Lindsay at the table. And for the first time, she writes a note, to her attorney and kind of slides it his way. And that's just the first time I've seen the woman do anything except sob. She continued to point out parts of the record that says she was acting completely normal and that these were records from the Tewksbury establishment that she went to. The prosecution asked if the hospital monitored her sleep patterns, and Dr. Zeizel said no. And they pointed out, well, don't you think that would have been an important thing to monitor with somebody who's saying that they were dealing with severe sleep issues since September of 2022? And he said, yes, that would be important.
On this particular individual's history would be an important thing for the hospital to monitor, correct?
I would agree with that.
She then began talking about something called confirmation bias, which is prevalent in psychiatry and among a few other fields. And Dr. Zeizel says you don't always need a diagnosis to have a mental disease or defect, while also saying that he does not have confirmation bias and that Lindsay is not his patient. However, the prosecution refers to the court records that shows he refers to Lindsay as his patient. We have a short video on that.
Now, in this particular case, well, let me ask you, are you familiar with the concept of confirmation bias?
Of course.
And fair to say it's pretty prevalent in most areas of science and forensic psychology and psychiatry, correct?
It courses all domains of work and life.
And as far as confirmation bias for psychiatry or providers, fair to say that clinicians are warned that they may lean towards or support their own theories and overlook contradictory evidence, and that you have to be aware of that, correct?
Yes.
And again, in forensic psychology, the goal is to render an objective opinion, right?
Yes, the facts come to you. You don't go to the facts.
Okay. And there's a danger for clinicians and forensic psychologists of quickly forming an initial diagnosis before having all the information, correct?
Yes.
And that confirmation bias accounts for the fact that a lot of times people, clinicians and providers will cling to diagnoses and interpret subsequent information in light of that kind of already perceived idea. Is that fair to say?
They cling, I just want to make sure I understand what you're saying. They cling to a diagnosis?
Well, once a diagnosis is reached, they cling to that diagnosis when interpreting subsequent information.
That happens, yes.
And but you would agree that in practice of forensic psychology that it's important not to do that, right?
Particularly with the guidelines of criminal responsibility where you don't need a diagnosis. You just need a mental disease or defect.
But diagnoses are helpful in understanding whether the person was suffering from this legal construct of a mental disease or defect, correct?
That's fair to say.
And it's fairly accepted in the field that if somebody has a disorder or a diagnosed mental illness, that they then in turn suffer from a mental disease or defect. Or could.
Or could, because you can have a phobia. Doesn't mean you have a mental disease or defect. If you're afraid to jump out of airplanes, it doesn't make you ineffective and have a defect or a disease. So yes, it could.
I ask you to keep your voice up.
Yes, Your Honor. So it could, but it doesn't always have to.
Thank you.
Of course.
And you're aware of the danger of this idea of confirmation bias of having multiple relationships and conflicts in this type of work, correct?
Yes.
And that's why it's important not to be treating somebody as a patient when you're also evaluating them for this type of legal issue, right?
Of course, you cannot be the therapist and the examiner. The therapist is an advocate. The examiner looks for the truth.
And Do you recall in this case submitting recommendations to the court in November of 2025 about the defendant regarding accommodations for her?
I know in general, but I don't know specifically what those accommodations requests were. I can't remember them.
But you authored and signed a letter dated November 13th, 2025 to the court, correct?
Yes, but I'm saying I don't remember specifically what those recommendations were. I know I did that.
I'm not asking you that. I'm just asking if you wrote the letter.
Hold on. Just ask the question. Doctor, if you listen to the question.
Yes, sir.
I'm asking if you wrote the letter, sir.
Yes.
And in that letter, you refer to providing essential clinical findings regarding the transportation of my patient, Lindsay Clancy. Do you recall writing that?
Yes.
And so at various points throughout over the years of this case, you have referred to it as your patient, have you not?
I wouldn't be, I think, able to define her as something else. She was a patient who I did a forensic evaluation of.
Well, you referred to the court outside of this evaluation you're testifying about to her as your patient in this letter from November 13th of 2025.
Right. I evaluated Ms. Clancy, who was a patient. If I evaluated her, then she's my patient, as she is other doctors' patients at Tewksbury and other places that she's been at.
But you call her my patient in the letter.
I wrote the letter. Whose patient would I be referring to if I'm speaking about Ms. Clancy, given that she's my patient? Yes, I wrote she was my patient. That's correct.
Okay. And you're aware of, again, the APA guidelines on forensic psychology, where it warns therapeutic forensic role conflicts. Providing forensic and therapeutic psychological services to the same individual involves multiple relationships that may impair objectivity and or cause exploitation or other harm. You're aware of that, section 4.02?
Yes.
And the last bit of business that we had for day 16 was the voir dire of Emily Thorndyke. You'll remember that she was the woman who had reached out to the defense via TikTok and wanted to set the record straight about McLean Hospital.
When Lindsay went into the hospital, it was on New Year's Eve. Is that correct?
Right. Mm-hmm.
And that she was there for that holiday weekend, and then I think the following Monday was a holiday?
Yes.
Okay. And you heard the direct examination of the district attorney asking about McLean being number one hospital in the country, McLean having all of these services available to the inmates that are in there, treating them, offering all these fantastic programs on the holiday weekends and the holidays, as opposed to what Patrick had testified to. Did you see that?
We re-asked that question. I think I understand, but.
Okay.
However, she has stopped working at McLean in December of 2021. Lindsay was there January of 2023. She wasn't even there when Lindsay was there. How in the world could you attest to how the standards of care, not rituals, but just the things that they do, you know, and how they do them and how they act and who worked where? How in the world would you think that your testimony would bring anything to the table? You weren't even there when she was there.
As far as the contact with the staff and the doctors, meaning nurses or social workers or whatnot, you haven't reviewed any of those records, right?
I have not.
And so you don't know the extent of what the interaction was with the nurse and the patient, do you?
I mean, there are some general guidelines that you have to follow. I can't tell you the content within them, but for example, mental health specialists, you're not supposed to meet with a patient longer than 20 minutes because you have other things to do. So I can't speak specifically to what happened in those conversations, but I know the general gist of how everybody's role works.
But you, when you say everybody's role, did you ever perform the role of a nurse?
No, but I work directly with them. I'm operating on the job description. It says specifically you're under the direction of the nurse. So I worked directly with nurses.
Do you go through the same training as a nurse?
No.
Regardless, that she would not be able to attest how things were, because that would just be pure speculation on her point, or excuse me, on her part. They asked her what part of the trials she has watched so far, and she responds with the direct testimony of Patrick Clancy. Do I believe that? No, I don't. Because first of all, she would have had to have heard the testimony about McLean Hospital in order to make a 10-minute TikTok video that apparently was very emotional about the fact that that testimony was incorrect.
Also worked on the exact inpatient unit at McLean for nearly 8 years that Lindsay Clancy was a patient at. Very important, I was not there when she was there, but I literally worked there for 8 years. We need to correct the misinformation that this prosecutor is saying about McLean and what the stay there is like. So I'm going to break down everything for you and tell you the truth. Let's preface this with identifying what the prosecutor's approach is with the McLean stay in particular. The prosecution is trying to say that if Lindsay really wanted to get better, why didn't she engage in treatment more? And then the prosecutor specifically talks about McLean, what's offered there, and identifies things that Lindsay did not participate in. And we need to correct that. Let me tell you how it actually works. So the first thing the prosecution brings up with Patrick Clancy is that he has stated that he felt like she didn't really get any treatment while she was at McLean. And one of the things that he was under the impression of was that she didn't really see a doctor while she was there. Now, the prosecutor then says to him, well, are you aware she actually saw a doctor each day and she saw a resident? Are you aware of that? And he says, no, I wasn't under that impression. Let me tell you exactly why that is. In general, there are around 23 patients on the unit at a time. And because of that, there are usually around 4 to 5 physicians in charge, we call them, 4 to 5 psychiatrists who split up the patients so that there's not just one doctor seeing 23 patients. Each doctor has usually around 5 to 6. They vary a little bit, but they are limited, and that 23 patient population is divided up and it's split amongst doctors. When a patient is admitted to the unit, they are specifically assigned 2 clinicians. One is a psychiatrist and the second is the social worker. You are literally told as a patient, this is your treatment team. This is your doctor. This is your social worker. With that being said, legally, every patient needs to be seen at least once a day by a doctor. So on the weekends and on the holidays, when the physicians in charge, the regular physicians who are working there, are off because they work weekday hours, on the weekends and on holidays, the patients still need to be seen by a doctor. How that works is that there is one doctor who comes on the weekend and holidays, and he or she sees every single patient on the unit, okay? And if you think about it, there's a reason that the doctors who are there during the week are only assigned 4 to 5 patients, because you cannot spend a long amount of time as a doctor with 23 different patients. So the job of the weekend doctor, as we call them, the holiday doctor, is literally to just go quickly check in with every patient. It is not a lengthy meeting by any means. So this idea of the prosecution saying, well, she actually did see a doctor, so that was kind of a lie. She saw a doctor. She didn't see her doctor.
She said that she had seen the direct testimony of Patrick Clancy before Mr. Reddington had sent a private investigator to track her down. And at that point, she was sequestered and told not to watch any more of the trial. Like I said, she stopped working there December 2021, okay? So she had no way of knowing what was going on in January 2022 when Lindsay was there. The prosecution made their argument stating that May of 2019 was actually the last time that she worked as a mental health worker,
As far as what your knowledge is of mental health specialists, fair to say the last time you were employed as a mental health specialist there and did that work yourself was in May of 2019.
Yep.
Which again is kind of funny because they put on so many unnecessary witnesses. But that's neither here nor there. Ultimately, the judge ruled no, she cannot testify, mainly due to two factors. One, she was not there when the defendant was there. And two, she would not be able to really bring anything materially. The judge has a hard time saying it, and I'm realizing now why. Like, material-wise, say that, to the case that's not already documented in the records from McLean at the time Lindsay was actually there. Our video there.
Also analysis under Rule 403, which is relating to relevant evidence. And as that rule, proposed rule says, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of, that part doesn't apply. First off, I find this witness credible. I find that, and I appreciate her being willing to offer the information that she has, but that's not always the whole finding on this. And so under cases such as Taylor versus Illinois, Commonwealth versus Dunning, Commonwealth versus Steinmeier, a couple other cases, I have to look at a number of factors. The first is prevention of surprise. Well, the Commonwealth has been aware of this issue for at least a week or so, so I'm not considering that. Evidence of bad faith, there's no bad faith I see from either side in naming this or calling this person at this time. There's the prejudice to the other party. I think there's just limited prejudice, if any, to the Commonwealth. However, though, the final two are the issues that I think are more relevant in this. One is the materiality of the testimony in this. And I find that there's limited materiality, that's hard to say, because mainly this witness hadn't worked there for a year. So there's at least a gap between when she worked there and when the relevant time period is here. There's also, I imagine, different personnel that are working on different shifts. And so there's kind of limited value to that testimony. I also, I don't remember any five-star type inferences. In fact, so I'm not going to, that's going to be measured by the jury. But I didn't see any mentions that this was a five-star facility. And then also the concern is, or the factor is, the effectiveness of less severe sanctions. And I would find that the records that have been brought in pursuant to the subpoena in the last couple of days from McLean's talks about the staffing levels on holidays and not on holidays. So if there's a question of whether or not there was a quote-unquote skeleton crew that was on for those, at least the first 2 days of this time that Ms. Clancy was there, that's reflected in the records. There also in the records here is a list of whatever programs were offered and also when they were offered. So if there's a question of less programs being offered on a holiday than during the week, those are contained in the records. And so I'm going to deny the defendant's motion to call this witness, but I am going to allow the defendant, if the defendant wishes, to submit those McLean's records specifically regarding the staffing and the programs that are available.
Court then ended for the day a bit abruptly. However, from a few sources, I have been advised that it was a scheduling issue with Dr. Spinelli, who I believe will be the defense's next and possibly last witness. So we will see if the defense rests their case tomorrow after Dr. Spinelli testifies. And for all of you asking, no, I do not think that Lindsay will or should take the stand. And I would really like to know what you think, if she should take the stand or not, or if you think that she will. Please put your, you guessed it, in the comments. Never know what will happen. We will have to see. And if you enjoyed the video, please like and subscribe so I can continue to bring you content and keep you up to date with not only this trial, but also other trials and also future trials. And thank you again for joining me for another episode of You Would Think. And hope you have a great night.